Well, hello everyone. I think everyone's kind of joining in. We'll give them a second here, but um, you know, we want to introduce Andy here and Michael. I'll let them do their own intros, and I'll save myself for last. So, Angie, nice to see you, Andy.
Nice to see you too, Andrew. Hi, I'm Andy Diroll-Black. I'm the Chief Compliance Officer for American Lending Center Holding, a regional center company here in the EB-5 program based in Southern California. I was previously a federal employee for 17 years, where I worked in a variety of adjudicative backgrounds, but spent about 10 years at the IPO, the Immigrant Investor Program office in DC. From I started there in 2013 as an adjudicator, worked my way up, became the acting division chief of compliance, and I was primarily responsible as the project lead for implementing the Reform and Integrity Act in 2022. After that, I did a stint with the DHS Civil Rights Office, and I joined ALC in September of last year. So happy to be here.
Yeah, and I'll mention also that gets me excited is we always talk about you being the architect of the 526E and the 956 applications, which everyone here I think has seen, and they're always interested to see like who's behind that. But thanks for being here. Appreciate it.
Of course.
Michael, I'll let you take the floor.
Thanks, Andrew. And it's great to also be here with Andy. Um, my name is Michael Harris. I am an attorney based in Miami, Florida. I've been practicing law for almost 19 years. I've worked in the field of immigration law for over 25 years, however. I'm a board certified immigration specialist, which means the Florida bar here, which licenses me, has certified that I'm an expert in immigration law. I've been involved in the EB-5 program since really the whole entire time I've been practicing law and in the regional center program for regional centers and projects since it really became a formal program in 2010. Before that, it wasn't really used as much and there wasn't a lot of formality to it. Today, I represent a lot of investors and projects and regional centers around the United States and write and speak on EB-5 matters quite often, and look forward to discussing this topic that Andrew Black has. Andrew Wall. I went to law school with another Andrew whose last name was Black. So this is going to throw me off for a little bit.
Ah,
So
no
great to be
worries.
here.
Yeah, thanks, guys. I'll give a quick intro of myself. So, Andrew Wall. I'm also based down here in Miami. I've been in the EB-5 industry for about 14 years, started working for a regional center, eventually got to the point where I wanted to show a lot of options for the clients. So I got licensed under FINRA. I'm a registered agent. We work with a variety of projects across the country. Andy's company is one of those regional centers. We do due diligence for the investors, kind of handhold them through the entire process and help them understand the structures, including pending changes into the USCIS program. And that's kind of why we're here today. There was an update a few weeks ago that Michael was very quick to create an article on. I don't know if you've seen it, but we can share it with you guys after this webinar. But right now, we're kind of understanding, navigating the new USCIS adjudication process and manual. So kind of start off there. We're looking and we're seeing a major shift in the USCIS with the EB-5 concept. Michael, with that policy that you kind of have an overview on your website, can you kind of explain what changed for the person that's just waiting in line that's already filed?
Yeah. So it was about it's a couple of weeks now where due to just my constant monitoring of different government sites. I employ a lot of technology in my law practice that helps me do a really careful job with the work that we do. So I was alerted, not just by refreshing the site all the time, but really with technology to solve this update that really just appeared there. That inventory management, and why exactly that was added to the government website, I don't know, but it was put there to I think provide a some type of reasonable. There were USCIS investment program offices attempt to provide a reasonable uh, process for how they will adjudicate cases. All of this stems from a lot of different reasons. So when the RIA was passed in 2022 of March, it's over 4 years now. It's crazy how time flies. But when the RAA was passed, one of the unique things that was in there was said that any investor that files their petition based on a rural project that is sponsored by a regional center will receive priority, or shall be prioritized. So that, as a result, led to the agency, at least from what we saw and happening in regular practice with I-526E petitions, again in regional center investments in rural project locations, be adjudicated at a faster time. Since that time, 4 years ago, there's been a huge demand on EB-5 regional center projects. A lot of investors have filed both in high unemployment areas and rural areas. And so, since the RA also set up a reserve visa category and three set-asides really now for rural high unemployment areas and infrastructure areas, with more investor visas being made available for rural locations. I think that, over time, due to this increased demand, USCIS decided to come out with this type of policy or statement on their website. Again, this inventory management is not in the law. It's not in any regulations. We don't have regulations yet. We haven't had regulations in a long time. It's not even in their policy manual at this point. It's just on the website. So this processing update basically tells us how USCIS expects to process EB-5 petitions, due to either the priority processing that's due for rural investors, as well as due to what looks like a lot of demand, and in my opinion, a lot of demand and maybe a limited supply of visas that we might see happen at some point in the future.
So we're working prior, we were mentioned from USCIS, they notified us they do a first in, first out process. But now they're saying this kind of managed inventory. I think that's a little ambiguous into what it could be. So that's
Yeah,
kind of the reason that we have you guys here to break through this and Andy kind of, go behind the curtain here and give us a little bit of
great,
background onto what is going on. Are they actually going to be
great.
changing their processes, or is this just some verbiage that's out there
And it's the
to
same
make it
thing they've
more
been doing
ambiguous?
anyway, perhaps.
Yeah.
Right.
So for several years, IPO has had a couple of different queues. Essentially, they would prioritize what cases were being assigned to officers based on whether a visa is available and whether the project has been reviewed. There was always a lot of every week managers would have to get together and kind of go over the spreadsheet to see, where the different petitions were, different projects were, and then get those assigned out to people in a semi-efficient manner. It was always a stop start, and as projects kind of were adjudicated and added to the queue, there was always this big reshuffling, and sometimes the file room would get overwhelmed. It seems like what they're doing now is they're creating another queue or a sub queue for rural because the rural cases very specifically are called out in the statute, as Michael says. And so I think what they've done is they've just created another band of files that they expect to prioritize. So instead of just first in, first out, where the project is done and the visa is available, now it's first in, first out, rural. And then at some point, when they've filled up whatever they think the queue is for when they've burned through the queue for the rural projects, then they move on to high unemployment and others. It's it seems to be an effort to be efficient. If I were in a fly on the wall in the room where they're making these decisions, I would think that it's USCIS and IPO in particular trying to say, okay, how do we manage all these cases coming in? We know we have this priority for rural, but there's only so many visas available for the rural designation every year. So why would we go ahead and adjudicate, 1,000 of those if only a few hundred of them will actually yield usable visas? So, we might create different kinds of backlogs if we over adjudicate. We might have some other problems. And so what they seem to be doing is creating what they think is the limit of necessary cases for the year, and they're going to put those up front and adjudicate them. It seems pretty straightforward. It seems like a nice, simple way to manage your work, do things in chunks, but I don't think they've really thought through what the downstream effects are going to be. I feel like there's going to be some unintended consequences, and we'll see those very soon.
Yeah, so this kind of sounds from a set aside level instead of a country of birth level, but a visa availability approach.
Hmm.
The kind of the same
Right.
concept is kind of what they're trying
Right.
to implement.
Right.
So Michael, when can you define this concept of empty or enough rule? Like, is there
Yeah.
legality to that for this enough
That
clause?
was the real interesting thing here in the update to the Q&A that they did. And just reading verbatim from it at the last bullet point that they have there, it says that, one of their considerations is assigning other 526E and post RIA 526 petitions by a FIFO, first in, first out approach, after the rural queue is empty, or when it says we determine we have made decisions on enough petitions for that queue. So I would think, and maybe Andy can reflect on the communications that go back and forth between the IPO, say in the visa office, on the supply and what the available visas actually are, so that USCIS takes an approach that if they see the wall is getting too high and it's going to crumble on them, or if they see that we're running out towards the end of the fiscal year and there are visas that have not been used in that particular year and they're going to run out, then they need to speed it up. Because remember, the RA also set up a new allocation method for not just these reserve visas, but for how unused or unissued visas get get allocated. Where if you don't use the visa in that particular fiscal year for one of the reserve categories, it rolls back over to that same reserve category for the next fiscal year. And after that fiscal year, in the third fiscal year, if those visas still weren't issued, then it rolls up to all the other qualified EB-5 investors. But on year four, after that third year, we don't know. I guess it goes up to EB-1 or something. So they want to maximize, I think, all of the visas that they can give out. I think there's probably, I would expect there's some type of congressional maybe pull here that they want to get as much investment out of these cases as they can. Remember, rural gets the huge benefit. So more investment, more cases, um, more flow of capital into the United States. Um, but the the determination of when they have enough, I think it's going to be strategic by them. I think when either due to policy, they just don't want to have such a huge supply of visas that are going to be locked for a long time, or and unable to be issued in a good enough time, or what. So curious what Andy thinks about that as well, of course.
So we never really had at IPO, we never really had a very direct connection to the State Department to talk about visa availability, like the various um, limits of what could be issued in a particular year. We were typically dealing with the USCIS headquarters office that kind of was the liaison for that. And I think if anybody is familiar with the EB-5 industry, they know Charles Oppenheimer. That guy was the government's leading expert on how visas work. And so he was certainly on the call sometimes where we would just kind of get some statistics of what the visa bulletin would look like. But ultimately, IPO was relying essentially on the final visa numbers to determine what counted as a visa available or not, and then would adjust the queues appropriately, or I would say not appropriately, in relation to those numbers. I have a feeling that they're doing something a little more like basic arithmetic, where, out of the rural set asides, that's 10% of the visas for any given year. That's 1,000 visas, which if we want to cut it, that's really only a handful, like a few hundred individual petitions that will likely be adjudicated to fill up those visa queues. So they might have some buffer in there, but they might decide that that queue of rural 526Es is relatively small, only a few hundred petitions. And that's because, again, the number of visas available isn't the number of petitions that are approved. It's every family takes away from that count. And so if you have 1,000 available visas and the average family is 3 or 4 people, then only about a quarter to a third of those petitions are going to yield usable visas that year. We were looking at that all the way back in like 2015 and 2016 when we started getting those massive waves of filings. where, for 10,000 visas being available in a given year, we would have 16 or 17,000 petitions filed. And so essentially using up the visas for years in advance. I have a feeling they're trying to learn from that challenge and just turn on a valve, essentially, to allow a certain number of petitions to move through the system that will cover all, and maybe with a bit of buffer, some additional visas that might be available throughout the year, and then cut it off so that they can then move on and do some other work and turn the valve on for HUA or for infrastructure. The struggle I have with that is it creates a lot of unfairness. It creates a possibility of very different outcomes based on when a 956F is approved, when any individual petitions are approved. If some or individual petitions are filed. So you can easily think of a scenario where two 956F applications, the project applications, are filed on the same day or about the same day. One of them sails through and is approved in 3 months, and those petitions start getting adjudicated. Another one, for whatever reason, takes 6 months. And so by that time, when that 956F is approved, we're now halfway through the fiscal year. USCIS, IPO may have already turned off the valve for rural applications. So yours are, I assume, just going to wait. So it creates this kind of unfairness based on a whole lot of moving parts that USCIS just simply has not told us how they're going to manage. It kind of goes back to, and I meant to mention this earlier, one of the problems we've had with USCIS and IPO in particular over the last year and last several years is the way they roll out this policy. And I have to thank you, Michael, and other practitioners for recognizing that this update to the bottom of the question and answers page was something to highlight this challenge. Because policy used to be rolled out through policy memos, through announcements, through this portal. Regulations would get done. We would have this whole, tapestry of rules that we could cite to when they were published, what the reasoning was, who signed it. But this is just an answer to an FAQ. It's really frustrating from a legal perspective because we don't know how that rule is being made. We don't have the opportunity to comment on it. We don't have the opportunity to challenge it. And you can see it in the wording very early in the announcement. It says that, IPO has broad discretion on operational matters. And that's true. They have a lot of discretion on how they manage their work. But this is something that, because they put it out this way, it seems like they're trying to circumvent like an APA issue or try to do some sort of rulemaking in, I don't know, like a fast food sort of way. Drives me nuts.
But it seems like this is just par for the course with USCIS, at least in the IPO level, and even because policy manual, stakeholder comments, things that they would do there. There hasn't been regulations that have been updated for I don't know how long. Has it been since '98 since we even had regulations or so, or maybe in the 2000s? So it seems like this is just their standard operating procedure to put it on the website. Maybe, I don't know why it's not on the policy manual, but it'd be great if those things were there. But, I know that there was that old case that, that was litigated over in L1 that they basically said, oh, the policy manual is not mandatory. None of this is mandatory. It's just meant to be interpretive and help the officers adjudicate these cases. So, I mean, to me, I guess it leads to some, makes everyone wonder why exactly are they doing this? For example, I'm sure a lot of us here read Suzanne Lizicki's blog, and if you haven't, you should, where she, analyzes the numbers, which she's had a lot of FOIA that's been done with the support of AIIA and their team pulling this out. That great to individual and an organization that I really think people should support. But the data that she writes about is that, just recently that there are maybe 15,000 people each in the rural and high unemployment areas, and 1,000 people in the infrastructure queue. So if there's that many people, whether they're investors or, two family members, it seems like there could be already enough as there is. And why won't is USCIS going to do something? I think that I just don't know anymore. We've heard maybe this year we might have some cutoff date assigned and everything. stops a little bit, but we'll see. Why take away, why cut off the demand when you can keep people filing and investing through the effective, date through the, when the regional center program expires next year. I
Yeah.
mean, that's what if I were being sinister, I suppose I would want them to do, but it would be right to have a cutoff date at some point to let people know, hey, how long are you going to actually be waiting for your green card for your I-45 to be approved, or if you're not in the US, overseas.
Yeah, so I deal with a lot of investors on a daily basis and attorneys as well, that are introducing me to potential clients. But a lot of the times they're almost always asking me for like rule approved projects, assuming that that's the express lane. With this kind of valve concept, that rule in concept could be turned off and it could be fully focused on high unemployment. And now you have this whole 956F bottleneck where you have now applicants. I used to tell them in rule deals, you're waiting 6 to 8 months from the day you apply, whether or not the 956F is approved. That's kind of the average processing time. Today, I'm assuming that's kind of changing. That 956F and that 6 to 8 months is starting when the 956F is approved. So that's kind of something I'm contemplating. I'd love to hear your opinion on that, Mike. Let me know kind of what you're seeing and what you're taking
I
from that.
mean, yeah, my understanding has been that review on the 526C does not happen until the 956F is adjudicated, because it would not conserve resources for them to review 526Es only to have the 956F not adjudicated or denied, for example. So
Yeah,
the
kind of
when
counter
the
to that,
when the
Mike.
526E gets adjudicated, I think can obviously it's going to be tied to the 956F, which we know that's been the way I think it should be before this policy update.
Yeah, but I mean, I guess I'm saying that because of just the experiences I've had. So we've had applicants file into deals and then get adjudicated within 2 weeks of the 956F being approved. It's kind of too much of
Mhm.
coincidence to say that they just started reviewing it once the 956F was approved. My thought process was maybe they reviewed this application, they gave them like a phantom approval, but not a hard stamp until the 956F was kind of adjudicated. Um,
Maybe, but I mean, I've met with other former IPO adjudicators, and they would say it would take them about maybe 4 to 5 hours to review a 526E. I'll let
okay.
Andy
Yep.
maybe
Yeah, that'd be good
disclose
data.
that, and that you could do a couple a day. So, uh,
Yeah. I guarantee there is no pre-adjudication going on.
Okay.
So the process is, as I said, once a project is approved, so 956 F is approved, all those cases that are related to it get filtered into the first in, first out stack, and they start getting assigned out. It really comes down to luck at that point. So if people are getting adjudication decisions within 2 weeks, their case was at the top of the stack. It got put on the desk of somebody who's efficient and good and knows what they're doing, cracked through it, and off it went. They didn't have other assignments going on. They didn't have vacation going on. And if you're lucky, you get an adjudicator who is doing a couple a day, and off they go. Unfortunately, not all adjudicators are created equal, and not all of them are trained the same. Not all of them have the same motivation. There are people who've been there for 15 years who are great and fast and good. There's people who've been there for 15 years who are not. And it's just the reality of government service. Sometimes you just have differences in people's abilities. Also, every case is different. You might get a case that you're cracking through, and then suddenly there's some very complex issue in the source of funds, and you've got to dig in, you got to do some research, call the fraud detection people, call a buddy across the office. And so anything can really change how that's done. But there was never really an appetite for pre-adjudication. And I think Michael hit it on the head. Like, what happens if you adjudicate it, it looks approvable, but then 956F is denied? Then everything just gets thrown back on a shelf, and you've wasted
Sure.
time you could have spent on something that was related to an approved project. Um, the the struggle I have is that it really comes down, because it comes down to so much luck. rural processing mandates are really for efficient adjudication, not assignment. And all USCIS, all IPO really seems to be doing with this is talking about how they're going to assign these cases. There isn't as much follow-up. There doesn't seem to be as much oversight as to what happens once those cases are assigned. And I've seen it in mandamus responses. I've been in the room when we discussed it. We just said, well, what? We put it on somebody's desk. What do you want? And everybody who has ever sent a 5 2 or an email to the inbox to ask how's my case going, they'll tell you either it's not outside of processing time or they'll say it's
Mhm.
been assigned. And that's it. That's the only information you get because that's all they feel that they're responsible for. This doesn't
That's
help give us any insight beyond that.
what would you say I don't know that we have an, insight into how they've taken their staff. Have they taken all of the staff and put them into one focus group to just work on 526Es, deal with, I know that they used to tell us how many
Interesting.
people were employed at the IPO, maybe how many are dealing with 956F and 956 adjudications and so on, and then other investor cases. And an IPO, for those that may not know, Investor Program Office, which is the EB-5 unit for USCIS. Andy, do you know how many people were there last you heard? Um,
Uh, I don't know what happened since Doge hit, but there were well north of 100 adjudicators. I want to say like 150 when I left in 2023. Some of them were new and were being trained, but they were all, for the most part, very good people to work with. Um, there was always a lot of pushback to have special assigned units for particular categories or even particular projects because of one, fairness. You didn't want to have one group of officers getting a bunch of relatively easy cases that they could crack through and have good numbers, and then another group get stuck with a bunch of things that have, a bunch of issues or problems that need to be worked through and are much slower. Partly that was because of the union. The union really wanted everybody to be on equal footing. And then there was also just kind of a sense that, for ratings at the end of the year, that people should be rated fairly and equally. If your job description is the same as the guy next to you, you should be held to the same standards. So people's work assignments, typically you'd order 10 cases and you'd get um, batches of things. So you'd get whatever's off the top, but then you would also have a couple of the non-regional center cases as well, typically one or two in your group of 10 cases. And what you'd get would be a mix. You wouldn't get a particular project. You might have 10 cases, you might have 10 different projects, and that could require a lot of work. You'd have to become familiar with the documents related to each project and move on. And if you're lucky, you got three or four of the same projects. So you only have to read those offering documents one time. But I don't imagine that they've strayed too much from that. And I can say that with some confidence because I know the people who are in charge, and their motivation is really to make sure that their employees are protected from political nonsense, from weird policies, and also from really just chaos. The people who are in charge, Elisa Emil, the chief of IPO, really takes it very seriously that her staff has like a good set of expectations for what their job will be like on a day-to-day or week-to-week basis. So it's unlikely that they've done anything radical in terms of creating new teams or focus groups or other special assignments beyond things that really need it. I think those would be like mandamus cases, for example, stuff that needs to be, very quick process and put in front of people who are experts. But I'd say that the general adjudication, you're just going to be dealing with that bell curve of, the good adjudicators and the slow ones, and hopefully yours falls on the one side of the curve and not the other.
So to kind of, I guess, recap for my understanding, in prior processes, you would apply and you would be assigned an adjudicator. In today's world, until your 956 is adjudicated itself, you're not being assigned an adjudicator for your 526E. That's what's changed.
I
Well, that's
think,
been the case
yeah.
because they've I think always said that 956F before 526E. That's been the order of operations, the flow, if you will.
Okay.
And that was
Yeah,
true
Andy, sorry.
pre-RIA as well. Yeah, that was true pre-RIA as well. You'd have the 924. And while the 924 exemplar wasn't required, it was helpful. And so if we didn't have an exemplar back then, you would take the first filing, the first 526 in the door, and treat that like the 924, review it, and once that project had met approval standards, that was the one that was used by the rest of the adjudicators to make determinations on business plan and so on. So it's always sort of been that way. And there's always been a queue related to project evaluation, even if it wasn't official. And now the 956F makes it official. That's how it has to happen. And IPO has treated that as gospel, even though the statute isn't exactly clear on that being a requirement. Operationally, it just makes sense, and that's the way that they've been following it. Um, I think the struggle is, and it's always been the case, is that no 956F is created equal. And so we're going to see a bit of uncertainty until we get some clarity on how they're prioritizing those as well.
Right.
And a
Yeah,
question
and
we kind of
that's
talked
one of my
about,
concerns coming up.
Michael. I mean,
And
Michael, Andy, we
yeah.
talked about this together the other day, kind of prepping for this. But so what happens in these processes where applicants file into an unapproved deal and the program essentially expires in September of 2027? Are these individual applicants at the 526 level protected? I mean, they are filing before the
Yeah.
grandfathering date, but the 956
Right.
isn't
Well,
indicated.
the RIA sets up this grandfathering clause in there, which essentially says that if you file your 526E before the sunset or the expiration deadline, which is September this year, then you'll be protected from expired legislation, and your future adjustments or immigrant visas or 829s will continue to receive adjudication. It doesn't say there that your 956, the 956F will still get adjudicated. So obviously you can't file the 526E until the 956F is filed. So any project you choose is going to have filed a 956F application before the end of September this year if you want to be grandfathered, since you can't file it at all. But my concern is, how will USCIS treat 526Es, say in August of 2027, that are undecided and the 956F has not been decided, or it's a complicated scenario? I just I don't know. Maybe Andy has some take on that.
I think that unlike the previous sunset in 2020, 2019, sorry, it's been a while, 21, the 956F is now an integral part of the process. It's a requirement. And so the likelihood that USCIS does nothing with those in the event of a sunset, I think is very, very small. I think what is more likely to happen is they'll get all the petitions together that were grandfathered, figure out which ones of those are associated with 956Fs that haven't been adjudicated. They will adjudicate those 956Fs before they go on to adjudicate any subsequent petitions because they have to. The system is now set up so that the business plan and the other, project information is offloaded into that 956F, but it is still in the statute kind of relates back, or I should say the petitions relate back to it. So in order for your petition to be adjudicated, 956F logically has to. I use the word logically, which I know dealing with this government is a bit of a challenge some days, but I think that the people operating IPO would absolutely be following that kind of thought process because it's not like the pre-RIA. The 924 exemplar was always optional. It wasn't a requirement. And so you could still adjudicate a petition on its merits because it should include that entire phone book of information. Nowadays, that's not the case. And so it kind of requires that 956F persist as well. For 956Fs that are filed
Right.
after the grandfathering, then we can talk about uncertainty. I don't know. But if it's prior to the grandfathering, I think the 956Fs will have to be treated the same as the petitions.
I think we'll see possible likely litigation on it, whether it's mandamuses. I'm not sure if 956Fs and 526Es will want to bundle together and try to litigate in a group on particular projects that are waiting for adjudication in order to benefit those individual investors. I think that a project would be very wise to consider trying to get an adjudication as fast as they can, right?
Yeah, I think so. I mean, man, we've already seen the mandamus dockets ticking up everywhere. I mean, everyone feels the pressure of these deadlines coming up. But I think there's something important to consider about this if we want to unpack a little bit of the nuts and bolts, is that an approved 956F is required under the current scheme for your 526E to move forward, but it's not required for you to file. You just need a 956F to be filed in order to get your 526E in the door. And so when people are looking at all these things and thinking, oh, I should invest in this project or that project. One of the things to keep in mind is really that the approval of the 956F isn't really going to tell you whether that project is going to be successful. It's going to tell you that it's going to allow your petition to move forward. That's one thing. But it still comes down to, the due diligence on the project. Is it going to actually build the thing it says it's going to build? Is it going to be operational, in 2 years, 3 years? Is the regional center that's sponsoring it, reputable? Do they have a history of success? Do they, you know, are they doing the things that they should be doing? Are they sharing information? Are they, working with investors? And then that's really something that only the investor and their attorney can figure out. And then the next thing to worry about is your priority date. You have that grandfathering deadline coming up. So you want to get your case in the door before then so that you at least have some kind of expectation of how it will be adjudicated in the future. But the key is getting that priority date set so that whatever happens with the visas, whether we have some sort of real backlog or shadow backlog with the rural or the HUA or whatever, however the unreserved visas are recycled back in, you still will get that date set down so that you can use it for whatever the future comes. So if for whatever reason USCIS doesn't adjudicate your case for a couple of years, then the priority date still determines when you can get your visa. That is probably the most important thing in terms of choosing when to file. And then in terms of filing like what project you're going to be a part of, I don't think the approval of a 956F is actually the defining factor. It's helpful. Yes, it gives you a little bit of confidence that the case will move forward, but I can tell you from experience, I had to terminate and revoke a lot of applications when I was the head of compliance at USCIS. My job was to root out those bad projects and find ways that we could salvage the investors if possible. But generally, we were just looking at trying to get rid of bad projects and bad regional centers. An approved 956F is only a preponderance of the evidence standard, and it will only tell you so much about whether or not your project will be successful. And I'll tell you one thing, and Michael, you can add on this if you want. It's a lot harder to wait, or it's a lot harder to get into a project, wait, find out it fails, and then have everything fall apart at the end of your process than it is to get in to a good project and then wait for the approval of that F. I think that waiting at the beginning, being patient at the beginning, is going to pay off a lot better for most investors.
And so,
Yeah, I agree. Yeah, I agree. You have to pick, you have that the project selection is key from not just the immigration perspective of, oh, they follow 956F, or even, unfortunately, even if the 956F is approved, there are other due diligence matters that you have to consider. Um, Not your immigration attorney, I don't see how they can, I don't think they're traveling around the country checking, kicking the tires on projects, or have conducted the same type of feasibility analysis that a financial analyst does. But we do play an important role, and you
Mhm.
have to pick wisely. Otherwise, you may not reach the finish line if the project doesn't hold up.
So let's say from an investor's perspective, they've already filed, but they don't have an adjudication yet. Does this March 30th effective date apply retroactively to those people already in line, or is just kind of new filings past that date?
I'm going to guess it does. I'm going to guess it's
Yeah,
spring cleaning from IPO's perspective. They're going to
yeah.
take everything in the
I
file room and
yeah.
organize it according to this. Yeah.
Yeah, I think it does. I wonder what impact it might have on pending mandamus cases that were filed before March 30th of 2026, because that policy was not in effect then. So maybe that gives them some more room, and any mandamus that's filed after that date, the government will be able to say, well, under the track factors that they evaluate for these mandamus cases, say, hey, we have a reasonable a way to deal with these, a rule of reason to deal with these cases. So there you go. Here it is, and maybe a judge will be less inclined to grant it afterwards. So I don't know if there's an uptake in mandamus cases right now or not.
I
What
could say
about the
I was going to say anecdotally, I think there has been, just speaking to other attorneys and knowing what my office is doing in terms of pursuing mandamus, I feel like it's definitely ticking up. Um, I think we see that because there's been a real slowdown since June of last year. I can, that's a whole other webinar talking about what's changed in just the last, 10 months. But There definitely are an increase in mandamus. I don't know that this will affect pending mandamus, and I think it's really just because of the way that IPO handles those. Essentially, mandamus are their own priority queue. Once a case shows up on the mandamus docket, the first question that's asked of IPO is, "Can you adjudicate it?" And if they can, then the attorneys, both at the Department of Justice and USCIS, will say, "Then do it. We want to dismiss this thing. We don't have time for this," and off they go. So mandamus does have the sometimes unfortunate effect of speeding up your case. Um, some people report that they believe that mandamus is kind of increased scrutiny of their case. I don't know if that's true. In my experience, it wasn't. It just got put with an officer who was told to drop everything and work on this for the next day or two. And so sometimes it might have a bit of that where there's increased scrutiny, but I don't think it was ever a denial machine. There was never a point where filing a mandamus was like, putting your foot in a trap. It was just something, it's a question. Can you do this today? And so hopefully that persists. Hopefully they keep going with that.
That's
Just keep it
interesting.
moving. Mhm.
What
Again,
about
that's a
what
whole other
about
webinar.
reviewing projects in line? So let's say there was an approved HUA deal and an unapproved rule deal. Does the approved HUA deal get deference for reviewing those 526 applications?
Once the 956F is approved, all the related petitions go into the queue to be assigned. It seems like what they're doing now is they've created a sub queue for rural. So once that rural project is approved, those rural cases will get stuck in the queue, probably at a higher level now, if I had to guess.
So we're getting some questions in here. I can kind of
Mhm.
go through these.
Yeah.
Let me look at a couple of them. So one of the first questions is, does this mean they will stop processing HUA petitions until the limit for rule petitions are processed?
Michael, you want to take a stab at that one?
I don't think so. I think it's going to depend. If you have a bunch of 526E petitions with earlier that are rural with earlier priority dates than an HUA one, but the F application for the rural ones is not adjudicated, but the HUA one is. Why would you let officers sit on their hands and do nothing when they could be working on those, at least during that 1 or 2 days, start working on those HUA cases? So I think they're trying to set up a type of type of flow pattern. Obviously, with these cues, if you want to visualize it, whether it's a Kanban board or something, a bucket that they have, and they'll get to ones as they can when they have the resources. So I think they're doing this, as I said, I think probably to maybe combat some of the mandamuses or try to, maybe actually do something the right way. I think, to their credit, the RIA has seen cases adjudicated faster than we ever have before. So something is being done right. I don't know if it's just the IPO or the fact that the RA is by itself, which requires the F application to be adjudicated first, also helps because before, like Andy said, you weren't required to file the business plan application, the 924. It was optional, and if you got 526 approved, anyway, that could serve as like the exemplar approval for your 526 cases. So I think that um, I'd like to think that we'll get better processing out of the government this way. I think that they've been doing so to their credit, at least at the EB-5 program level, for good or bad. They have been coming out with decisions and actions on this. The biggest question, obviously, I think to consider is what's going to happen after all of these cases get approved. Where is the individual going to be in the queue for a visa or for their 485? How long will the 485 remain pending if you're just here? Will it just be sitting there for quite a while? What's the real impact going to be on those processing times for the 485 later on?
So
Yeah,
I
that's one of the questions out there if you guys are reading the questions, but
yeah,
it's
can I
pretty
just
much how will USCIS's new policy help that issue at all, if at all, for handling the 485s? Because that's really where the stronghold is with USCIS.
So two things. Let me kind of counter what Michael said, and this
Sure.
isn't to. I think that his view is valid and as good as we can read in the tea leaves. The thing I struggle with is the way that the notice is phrased, the questions and answers thing is phrased about this, is that it seems like USCIS will be dropping everything for a period of time and adjudicating nothing but rural. That's just the way they've phrased it. I don't know if that's the case. I hope it's not the case. I hope Michael's version is the right one, but it's just something that knowing the people who are there, that's something they would have pitched, and it might actually be the case. Um, but yeah, I like Michael's perspective, and I think that he's got a good handle on it. And it seems weird for them to just drop everything and just do this one queue in maybe a month and then do no rural for the rest of the year. That seems to me to be unfair and problematic in so many ways, and I hope they thought through that. When it comes to the 485s, the struggle there is those are done in a different office. IPO does not adjudicate 485s. They're done at the service centers and some satellite offices, and so you're subject to those queues, whatever they are. Um, that's something we struggled with at IPO. We wanted to do 485s. There was certainly a resource issue because we didn't have enough people to really handle them. Not everybody we recruited for IPO had a strong adjudicated background in, the more bread and butter type stuff. But it's one of those things where USCIS has just agreed over and over again to put them into the service center queues. Um, Something else to consider is that to talk about what Michael said earlier is within IPO, they made amazing strides post RIA, and I would say even before that, in training people up and getting their workflows in order so that they could tackle this huge backlog that had accumulated. And I'd say that it was a change in leadership at the headquarters level last June that threw a wrench into it. I think we had just amazing times coming up in the beginning of 2025. We had 956Fs being adjudicated in 2 to 3 months. We had, 526Es being adjudicated within weeks or months of being filed, which is crazy to me. And from my experience, it's not crazy objectively, it's just crazy from my experience. And then that all kind of slowed down and changed dramatically in the summer last year. I can, again, do a whole another webinar on that one. But it's again, I think goes back to what I hope is the case. I hope that this is meant to be an efficiency measure that will yield positive results. I just don't know. I think you're muted, Andrew. We can't hear you.
Yep. So I think we have one more question here, unless you guys want to pick one off this list, but this one's an interesting one from kind of behind the curtains concept. The question is it accurate that USCIS assigns a single adjudicator or team to each I-956F approved project? If the project begins receiving I-526E approvals for early investors, can we reasonably expect the subsequent application to be adjudicated promptly?
Unfortunately, no.
I've heard that, but I'll let Andy answer that one.
Yeah, unfortunately, no. Typically, what will happen is an adjudicator, like the cases are put into the general queue and they get spread out on a first come, first serve basis. If a bunch of cases were filed at the same time, it's more likely that when they're assigned out to adjudicators, one adjudicator might get a bunch of them, 5 or 10 of them at a time. But the likely outcome that you see where you see regularity or common elements in, say, requests for evidence or NOIDs, is that one of the first officers who's assigned those will create a template that other officers can use. And so sometimes there's some efficiency there. Other times you just kind of get stuck with one officer's interpretation and it becomes an internal battle. But no, single officers or single teams are not usually assigned to particular projects. That was the case back in like 2015, but they moved away from that for a lot of different reasons, as I mentioned earlier.
Well, if you guys want to kind of sign off with one comment that you've gathered from everything we've talked about, and then we'll head our ways.
Sure, Michael, go ahead.
Yeah, so I mean, there's I think some other questions in there, and maybe some of them might
Yeah, if
not
you want to go
exactly
after
be
one, happy to answer
on
them.
topic exactly there. But I think one person asked, which is interesting, about the process for switching between reserved and unreserved visas. Now we know there's been that kind of option at the NBC level where they will send us a notification saying that you have been approved, and you have to make a choice. Do you want the unreserved or you want the reserved visa? So, but USCIS I haven't seen them come out with a procedure on that. I haven't heard any other lawyer comment about that they've received a notification from USCIS to receive one or the other. But so I don't know if it would just require each individual lawyer to try to mail USCIS, send them a regular letter or email the IPO as well, and ask for them to adjudicate one over the other. Andy?
Yeah, I'm not really sure. So, and I'm sorry, I was answering a question in the Q&A, just typing an answer. But I think without real clarity from how USCIS is making decisions, it's not really easy to know. We can guess. I think your position is as good as anybody's. I think you've got a lot of good background on this. You've done a lot of research, and I think that
So,
um, go ahead.
like here's a question, a follow up to you, Andy, that might help you. The way I think about it is before the RIA, when we had how many reserve visas for just was it for TEAs that were reserved? Was it 3,000 or how
I
many
think so.
visas were reserved? So if now every year, most of the visas, like 90 something percent, were to the TEA investors.
Right.
So simply because they hit the reserve didn't mean that they weren't going to adjudicate those reserve visas. I think they issue them. They might issue visas based on priority date down at that point against the whole pool. So if you have a reserve visa and they run out of supply on the reserve level, but there's a lot of unreserved available, I would think that they're just going to pull the visa based on your priority date when it's available on under either. I don't know if that's why I'm kind of confused about the whole
Right.
election method with the NBC. Really, use the visa that's going to get me here the fastest,
Right.
and use the most economical method at the NBC to keep the supply of visas available to people. Yeah.
I think that's right. And I think it's just because there always was a motivation just to get people the visas that they were eligible for. And so in pre-RIA, we only had the one reservation, but it was moot. I mean, like you said, 90% of the cases were TEA, so the reservation didn't matter. There was almost no point to it. This one's a little different because it's carved up so much. I feel like we're in danger of having USCIS deciding that those are quotas, not, I don't know, those are top limits instead of bottom limits, if that makes sense, where they're going to just adjudicate the ones for the 10% of the set aside and then 20% of the set aside for the HUA, and then they'll have some other math for how they do the rest. And I think that that's crazy, but I don't know with the current administration whether that's impossible.
So in other words, the inventory management should address this by saying that even if reserves are not available, we're just not going to stop processing these cases. We'll
Right.
just move through and treat everyone equally and adjudicate, approve or deny, and so on,
Right.
and send to for approval of issuance, to the 45 or the IV at the MBC.
Yeah, the struggle is they don't give us any clarity as to whether how they're going to do
Right.
that. They, like I said, if you, one way you can read that is we're going to drop everything and do rural. When we're done, we're done. We're going to move on to the HUA. And I think that is a crazy proposition, but it might be what they want to do. And then the outcome is that they've made this arbitrary kind of decision that we're only going to adjudicate so many cases in each category each year. And I don't know how that flies. I mean, especially considering the way visa processing works in different areas or in 485s, you just have different timelines based on where you're located, based on which country you're from, based on your work history. And those things just are so complicated that I don't know why you would produce something this arbitrary and obvious and opaque. I would just want a simpler rule. I'd want something real straightforward. It's clean, it's clear, and unfortunately, they haven't been able to pull that off.
Yeah. I guess if you focus on just rural, does that potentially create a backlog within rural faster than high unemployment?
I don't know. I think what it does, it creates a shadow backlog,
Yeah.
right? Like, especially if they have these cutoffs. Like I said earlier, depending on when your 956F gets approved, your petition may or may not be adjudicated inside that cutoff. That's just going to tempt dozens or hundreds of mandamus cases, honestly. And then it's going to question this so-called rule of reason, which I don't think they've really articulated in this case. But all that aside, like, I don't know. I think that in the end, if you get your case filed before the grandfathering date, it will be adjudicated at some point in the future. If you're with a good project, you will see success. And even so, even if you don't make it inside the grandfathering deadline, there's still another year where the program will be valid. And it would be, we didn't have a grandfathering statute prior to the RIA. So I think there's still a good chance that even if everything goes poorly and that the program does finally sunset in 2077, which I think is wildly unlikely, that I think any case that gets filed before the end of fiscal 27 will still be adjudicated. I think that's very, very likely. Whether it'll be under the same rules or whether there will be some other kinds of restrictions, I don't know. But I still think that getting your petition filed sooner rather than later is a good idea, and picking a good project is the way to go.
Yeah.
The other thing, and I do a lot of doom and gloom, but I like to end on a high note. I think the likelihood of reauthorization is very, very high. We have support on both sides of the aisle in different jurisdictions. We have very rural members of Congress or members of Congress who represent very rural districts, people who represent very large cities, big states, small states. We have people all over the map who are interested in giving this program more time and more juice. The question is how and when. And as my colleague Gary Merson often says, Congress doesn't do anything until it absolutely has to, and usually a couple of weeks or months after that. And so we just have to be patient and keep fighting the good fight. So, on my perspective and my team, and I know all of us and our colleagues are working very hard to make sure that we have a good program, that we represent good people, good companies, and then we talk to our members of Congress and our senators to say, it's a
Yeah.
good program. Keep it going. Like, let it fly. Because as soon as you do, you can see the effects. There are pieces of this country that were transformed by the EB-5 program. I mean, here I live near DC. The waterfront area of Washington, DC is absolutely stunning compared to what it was 10 years ago. And that is by and large because of EB-5 money. So it doesn't take much, but it does take a concerted effort by all of us.
Yeah.
So we're working to do that now.
Yeah. The other closing thought I guess I'd have, because there seems to be a lot of other questions on this, is we don't exactly know how USCIS is going to apply this policy, whether it's going to be in this scenario or what the scenario exactly is. We don't precisely know. We don't have that looking glass precisely. I think via FOIA, via mandamus or litigation, more information will come. And it'd be great if USCIS provided more information, but I don't see them doing that. They move at like a very slow pace in terms of revelations of new information coming out from them or updates to the policy. If you get it a couple times a year, it feels like a lot sometimes.
Yeah. Yep. So I think we can wrap that up a little bit. We're kind of ending time. End of the day, do pick a good project that's gonna, protect your capital, get you your immigration benefits. It may not happen tomorrow, it may take a little bit longer, but file before the grandfathering if that's your intention, and that will give you the most secure path to residency. But thank you, Andy. Thank you, Michael, for being here. I think everyone was really appreciative. And if you guys have any questions, you can reach out to them directly. We'll share their personal information for you to reach out. Bye, guys.
Thanks, everyone.
Thanks, Andy and Andrew. Thank you. Bye.
Thank you.